Good evening, ladies and gentlemen. Welcome to the Law School. My name's Carolyn Evans. I'm the Dean of the Law School, and it's my great pleasure to welcome you all here tonight for the 2012 Sir George Turner Lecture, The Changing Face of Legal Education in China, which will be presented tonight by Professor Geoffrey Lehman. Before we begin, I note that we meet today on the traditional lands of the Wurundjeri people of the Kulin Nations and pay my respects to their elders, past and present. Tonight's proceedings will be recorded, will be available soon from our website, and if you could bear that in mind when you're asking questions, that would be helpful. Before I introduce our guest speaker tonight, let me just say a few words about the Sir George Turner Lecture. It was conceived of more than 6 decades ago when Miss Grace Melbourne Turner, who passed away in 1959, made provision in her will for a lectureship in law to be named after her father, Sir George Turner. Sir George was an alumnus of this law school, a distinguished lawyer whose practice would go on to be consolidated into what is now the cause legal practice, and he was also an important political figure of the Federation period. He began his life in politics as Mayor of St Kilda, went on to be elected to the Legislative Assembly where he served as Solicitor General, and then became the first Australian-born Premier of Victoria. He resigned in 1901 to enter federal politics and, as Treasurer, delivered the first 4 Commonwealth budgets. During his career, he was appointed a Knight Commander of St George and St Michael, a Privy Councillor, and was granted honorary degrees from the universities of Cambridge and Oxford. So a very distinguished alumnus of this law school, and we're delighted to have this lecture in his honour. We're particularly delighted that tonight the lecture will be given by Professor Geoffrey Lehman. Professor Lehman has been Chancellor and founding Dean of the Peking University School of Transnational Law since 2007. He is a graduate of Michigan, where he graduated with advanced degrees in law and public policy, and of Cornell University, where he has an undergraduate degree in mathematics. This makes him that rare and dangerous creature, a numerate lawyer. After graduating, he became a law clerk to Chief Judge Frank Maury Coffin of the Court of Appeals, then to Justice John Paul Stephen of the United States Supreme Court. He practiced in Washington, D.C., returned to the University of Michigan, where he was a professor of law and then Dean of the University of Michigan Law School. At the age of only 38 at the time, the youngest dean of a major law school in the United States, and it was perhaps then unsurprising that he became president of the American Law Deans Association. He returned to Cornell as president in 2003 and was the first Cornell alumnus to serve in this role. He is currently on leave from Cornell. His talk tonight will no doubt be informed by this experience at the very top level of US universities and law schools. But we're particularly interested in his reflection on his very interesting role as Chancellor and founding Dean of the Peking University School of Transnational Law. Some of us had the privilege of having lunch with Professor Lehman today, and he spent a little bit of time talking to us about this really extraordinary and interesting experiment. I don't want to steal his thunder, so I won't go into it in any detail. But this is one of the law schools of the future. This is sort of a thing that I think most of us couldn't have imagined 20 years ago and will continue to be setting a trend, I think, in 20 years' time. We're very grateful to him for taking the time to come here tonight and speak to us, and I now call upon him to deliver the 2012 Sir George Turner Lecture.
Thank you very much. I want to begin by thanking all of you for inviting me to speak this evening at this magnificent law school and this magnificent university. And I would like especially to thank you for inviting me to speak under the mantle of Sir George Turner. Every great law school understands its mission to entail an admixture of goals that are at once technical and spiritual. The technical goals concern the nurturing of certain intellectual skills within students' brains and the transmission of certain points of information to them that might be analyzed with the aforementioned skills. The spiritual goals concern the development of certain values, certain public values. We want our graduates to understand themselves to be members of a noble profession. We want them to feel a responsibility not only to serve their clients well, but also to participate in the progressive betterment of society. We want them to feel that their special powers, no matter whether they are called lawyers, attorneys, advocates, barristers, or solicitors, come impressed with a public trust. One way in which great law schools convey this sense of public duty is to remind students that they are heirs to a great tradition. They sit in the same seats, and they struggle with the same intellectual problems as great people, famous people, important people from prior generations. And what better way is there to offer up this gentle reminder than to assign the name of a prominent former student to a professorship or to a public lecture? So when I saw that I was to be delivering the 2012 Sir George Turner Public Lecture, my first reaction was happy and familiar recognition. I saw that this law school, like other great law schools, was participating in this enlightened practice of none too subtly reminding students that they are the modern heirs to a distinguished tradition. But then I had a second reaction. You see, I also know from my past experiences at other institutions that the great names that are associated with public lectures are sometimes associated with human beings who were in some ways surely admirable, but in other ways, shall we say, somewhat more complicated. Because time tends to march forward with a soothing forgetfulness, these latter cases are rarely sources of deep consternation. Few in the audience are aware of the more troubling dimensions of the long-departed one whose name blesses the gathering. But still in all, I have witnessed occasions where some members of the audience were privy to the unseemly details of the named person's past life. And almost invariably, those members of the audience would enjoy a private smirk at the speaker's expense. If only that speaker knew just whose name they are proudly associating themselves with. Well, once I was stricken with this second reaction, I had no choice but to run out and learn what I could about Sir George Turner. And now, having done so, I again say, thank you, thank you, thank you. As best I can tell, Sir George was genuinely the sort of person that a great law school wants to hold up as a role model for current generations of students. He was a good student, he was a good lawyer. During a crucial period in the development of the Commonwealth, he found his true calling in public service. He served admirably as Premier of Victoria, steering the then colony past the shoals of a Great Depression, and he served just as admirably as the Commonwealth's first treasurer. He was not flashy, he was not wild, he was shy, he was earnest, he worked hard, and he was pragmatic. In the words of the Australian Dictionary of Biography, quote, Turner's capacity for work, mastery of detail, patent integrity, frankness, unpretentiousness, and geniality won general trust. It seems to me, therefore, that the University of Melbourne Law School has shown outstanding pedagogic judgment in naming these lectures after Sir George Turner. And that act of pedagogic judgment leads me naturally to my primary topic this evening, the pedagogic judgment that Peking University demonstrated when it decided to create a new kind of experimental legal education for China. As Dean Evans has advised you, I am currently serving in the employ of the Peking University School of Transnational Law, which we like to call STL, for School of Transnational Law. Now, there are many different ways that one might choose to contextualize what China has undertaken with STL. One might, for example, choose to describe the event in national terms and in legal terms as a part of the story about China and law. By this account, STL is a very small part of a much larger and deeply complicated effort within China to move from the Hobbesian state of nature that it experienced during the Cultural Revolution to a modern society expressing a commitment to the rule of law. As interesting as that contextualization is, however, I prefer to frame it in more transnational terms as part of the story of globalization. And I do so largely because of STL's parentage. You see, STL was not the brainstorm of a law professor or a judge steeped in matters of law and justice. The true father of STL was an economist an international economist named Hai Wan. I'm glad I have your approval. The economic story of the 20th century's concluding decades was a significant story about globalization. Improvements in transportation and telecommunications technology dramatically lowered the transaction costs associated with international trade. As a consequence, the global economy and global society were completely transformed. And that transformation, in turn, had implications for the transnational legal regime. Most notably, globalization intensified the demand for a more harmonized global legal structure. In the first instance, and most powerfully, the demand came from commercial actors, buyers and sellers of financial capital, goods and services in the world's marketplaces, but it did not stop there. Demand for a harmonized global legal structure also comes from outside the commercial sphere, from governments, NGOs, and private individuals who want to move around for non-economic reasons. Now, I want to be clear, a harmonized global legal infrastructure is not a uniform global legal infrastructure. The legal world may be a bit flatter than it once was. Certainly, the problem of individuals having to deal with directly inconsistent and irreconcilable national rules is fading. But true uniformity, whether substantive or procedural, is not anywhere on the horizon. The reality of multiple sovereigns creating multiple legal regimes is here to stay. On the other hand, the legal regimes are becoming just harmonized enough. We have achieved a working consensus in favor of regulated market economies interacting with each other under the WTO's regime of regulated free trade. And that is enough to have triggered an exploding number of actors who work across borders and who want to be served by a transnational legal profession. I mean lawyers with different databases of primary legal knowledge, but common intellectual skills and common understandings of what it means to be a lawyer. This demand has led to a number of rapid changes in the global practice of law. Most significantly, we have witnessed in recent times the emergence of huge multinational law firms. There are now about 30 firms in the world that employ more than 1,000 lawyers each. A majority are based in the US, but the centers of gravity are becoming more and more dispersed. Last week, King & Wood Mallison's officially opened its doors with 1,800 lawyers in 21 different countries. Interestingly, to grow this large today, law firms have departed from the prior models of global legal expansion. Historically, American law firms opened branches overseas in the manner of colonial powers. They sent American lawyers overseas from the motherland. But since 1990, as law firms have needed to grow more quickly, they have, in the words of Professor Carol Silver, done it by going local, by looking for local lawyers or local law firms following the so-called Baker and McKinsey model and incorporating them into a large federated structure. Now, these firms have not, importantly, gone completely local. They have been eager to engage lawyers with substantive expertise concerning the law of the local jurisdiction. But at the same time, the anecdotal evidence that I have from speaking with dozens of lawyers in such firms and with the in-house counsels, offices of multinational companies that hire such firms is that they are not interested in deferring to local understandings of what it traditionally has meant to be a lawyer. You see, those local understandings of what it means to be a lawyer be wildly different in different parts of the world. In some societies, the role of the lawyer was historically rather passive and reactive. A client described a situation. The lawyer was supposed to fit that description the facts into the official rules, the law, and expound to the client his or her conclusion. People in other professions, such as accounting, would play the kinds of roles that lawyers have come to play in the common law universe, much more active, participatory counseling roles. Now, today, the transnational law firms have rejected the passive, reactive role. They are being structured to provide the active kind of service that has traditionally been provided in common law countries. And they are doing so for one reason: their clients are demanding it. That background transformation in the transnational legal profession is what lay behind the inspiration of the economist Hai Wan. So Peking University, which is also known as Beida, short for Beijing Daxue, which means Peking University, is China's oldest and most prestigious university. Its main campus is in Beijing, and it is home to a law school that is one of China's best. In the 1970s, during the Cultural Revolution, China had only 2 law schools, in Beijing and Jilin, and they weren't accepting any new students. After the Cultural Revolution, with the emergence of the process of what was called reform and opening up, China had to open and reopen law schools very quickly. And when it did, it made a crucial bet. It decided to structure its law schools primarily on the continental European model. By that I mean they decided to treat law as an undergraduate subject whose study is oriented primarily towards the mastery of doctrinal rules based upon reading and lecture classes. Now, in 2001, the city of Shenzhen, which is the mainland's twin to Hong Kong and has a population of about 14 million people today, gave a campus to 3 of China's top universities, including Beida, to be used exclusively for graduate and professional education. Here's the campus. Today, Haiwan is the leader of this campus of the university. Haiwan grew up in China, spent the Cultural Revolution in the northeast part of China as a teacher, then came back to Beijing to be an undergraduate economics student at Peking University, and then did graduate work in the United States at the University of California, Davis. That's where he earned his PhD in economics. He became a tenured faculty member at an American university and settled down. And then in the 1990s, he was called back to China to return to Beijing to help Peking University launch the China Center for Economic Research, which was the country's first research institute focused on market economics. The China Center for Economic Research was enormously successful, and Haiwan was promoted to vice president of the university, and in 2005, he was assigned responsibility for this campus in Shenzhen. Haiwan's philosophy for the Shenzhen campus is to make it as internationalist and as Western-oriented as possible. His goal is to have all of the graduate schools on this campus teach their courses in English and draw their faculty from overseas. And at the end of March 2007, Haiwan came to see me in New York, for as an economist, he had noticed something that he could not explain. By then, 2007, China had opened more than 600 law schools. The law school in Beijing, Peking University, was generally thought to be the best of the 600. Some of the graduates of these law schools, and especially Peking University Law School in Beijing, were exceptionally talented intellectually. And Haiwan knew them personally. They were brilliant. They were incredibly hardworking. And yet, even the graduates of China's very best law schools were unable to get jobs at multinational law firms as real partner-track associates unless they first did advanced study, preferably at American law schools. Now, it just made no sense to Haiwan that China should be outsourcing legal education to the most expensive place in the world. So he wanted me to think with him about whether Beida could develop an experimental law school on the Shenzhen campus that could supply more of what the multinational law firms were demanding at a much more reasonable price. Well, we spent 2 days discussing this question quite intensely. Those 2 days then led to 3 months of back and forth discussions and conversations. And at the end of that period, we agreed that we would try to launch STL. By the end of the summer, we had received approval from the Academic Degrees Committee of China's State Council, which is their cabinet. The State Council authorized STL to offer, as an experiment, a new model for legal education in China. So we might call it a modified Melbourne model, or we might call it the STL model. STL is a freestanding school within Peking University that operates independently of and side by side with the Peking University Law School in Beijing. Like the other schools on the Shenzhen campus, STL teaches its courses in 6-week-long modules instead of in semesters. Students take 2 classes at a time instead of 4 or 5, so over the course of a year they end up taking 12 classes normally. At STL, our first-year curriculum consists primarily of common law courses that are standard in the first-year curriculum of American law schools: property law, contract law, tort law, criminal law, American civil procedure. Our first-year curriculum also includes 3 courses that are somewhat less standard in American law schools, in the first year at least: transnational law, professional responsibility, and corporate law. Now, alongside these courses that each last 1 or 2 modules, our students take the first year of a 2-year-long program that we call Transnational Legal Practice, or TNLP. TNLP is directed by Craig Hoffman, who is a member of the faculty at the Georgetown Law Center in Washington, D.C. And Professor Hoffman specializes in teaching American legal discourse to students who are not native speakers of English. The central point of TNLP is that attorneys do not speak and write with only one voice. The program pushes our students to be thoughtful what is appropriate for each different context in which a lawyer operates, and then to give the students practice in using those different lawyer voices. So in the first year, the emphasis is on the context of a lawyer in a law firm that is representing a client in litigation. So students practice drafting emails, memoranda, and court briefs, and then they have a mock oral argument before a moot court. In the first half of the second year, the emphasis is on the lawyer in the context of negotiating and documenting a contractual agreement on behalf of a client. The students learn about how lawyers in such contexts can create economic value by using contractual devices like representations and warranties to solve some of the economic problems like imperfect information and moral hazard and the obstacles to contractual agreement. In the second half of the second year, the emphasis in TNLP is on the context of a lawyer writing a scholarly article about a legal issue in her own independent and authentic voice. Now, this set of exercises launches the students on the work that culminates in the fourth year in the preparation and oral defense of a 60-page thesis, which is a graduation requirement at STL. Now, I think that all of this is a pretty sound design for a transnational law school, healthy structure that reflects, I think, a healthy philosophy, but it does not begin to capture what has made STL an exciting venture for me and something of a phenomenon in China. Because what has actually happened in Shenzhen has been far more exciting than Haiwan or I ever imagined possible. The real story of STL is actually not about the structure or the framework that I outlined. It is about STL's emergence as a magnet for talent. So I'd like to show you some of the faces of the senior leadership of STL and its faculty. This is our Associate Dean, Stephen Yandel. Stephen Yandel was the Associate Dean of the Yale Law School for 17 years. After that, he became the Deputy Consultant on Legal Education for the American Bar Association. He then became a Senior Vice President of the LexisNexis Corporation. He and his wife, Martha Ann, moved to Shenzhen 3 years ago to help start STL. This is our Assistant Dean, Xu Hua. She was a top graduate of the Peking University Law School in Beijing. She turned down offers from top law firms in Shanghai to come down to Shenzhen and help start STL. This is Peter Malensuk, the C.V. Starr Professor of Law. He was the Chair of Public International Law at the University of Amsterdam. He was the Dean of City University of Hong Kong's Law School. He moved to STL 4 years ago to help start our school. This is Francis Snyder. He is also a C.V. Starr Professor of Law. He was the Dean of Law at the European University Institute in Florence, Italy. He was a faculty member at the London School of Economics and the College of Europe in Bruges. He is the founding editor-in-chief of the European Law Journal, which is the leading publication in its field. He moved to STL 3 years ago to help launch the school. This is Ray Campbell. He is Assistant Professor of Law. He was a Supreme Court law clerk for Chief Justice Warren Burger at the United States Supreme Court. He was a partner in 2 different transnational law firms. He and his wife moved to Shenzhen so that he could join our faculty. This is Mark Feldman, Assistant Professor of Law. He was the director of the NAFTA-CAFTA Treaty Arbitration Group at the Office of the Legal Advisor in the United States Department of State. He and his wife moved to Shenzhen so that he could join our faculty. This is Sang-Yup Kang, Assistant Professor of Law. He's Korean. He earned an SJD from Columbia Law School, was described by the chair of his dissertation committee, who I know well, as the best student he had taught in 25 years. He chose to move to Shenzhen to join our faculty. That's our permanent faculty. At this point, they teach less than half our courses. Most of our courses are taught by visitors, and the visitors are perhaps even more dazzling. They include people like these. These are 3 members of the Harvard Law School faculty: Charles Ogletree, who taught criminal law to Barack Obama and Michelle Obama, Matthew Stevenson, and Jack Goldsmith, all senior tenured faculty members at Harvard. This is Michael Klausner from Stanford, George Fletcher from Columbia, Bill Allen from NYU. These are not only distinguished faculty members at these top law schools, these are among the most gifted teachers at these law schools. This is Paul Stephen from Virginia, Whitmore Gray from Michigan. So, given how interesting China is today and how curious everyone is about China, I guess it may not be too surprising that these people and others might want to come to STL and teach a class once as a visitor. That's not what is amazing about STL. What is amazing is that just about everyone who has ever visited at STL, including all these people, has asked if they can return to do it again and again and again. Now, the $64,000 question is why? And I have 3 possible answers to suggest. The first is the excitement of offering something new. Now, our teachers are not teaching new subjects for themselves, and they are not teaching any different from the way that they teach at their home schools. But this way of teaching is new for China. The STL model of legal education is graduate rather than undergraduate education. It combines a Juris Master degree program in Chinese law, which is taught in Chinese in the traditional Chinese way, with a new experimental degree that the State Council authorized, which is certified in the English language as a Juris Doctor JD degree. This new JD program is different from undergraduate legal education in China, and it is different from graduate legal education as it had previously existed in China. Classes in the JD program are taught in English, and like American JD programs, the central understanding of the mission of the JD program is different. The goal is not to offer students a theoretical understanding of law and legal institutions in the way that one might study history or political science. Instead, the goal is to offer a professional education which is designed to help the students to develop the intellectual skills, the ethical values, and the practical knowledge that are characteristic of outstanding transnational lawyers. Our program emphasizes two intellectual skills in particular. The first is what Professor Elizabeth Mertz has described, actually with some irritation, as living in an acontextual context, which is the ability to generate abstract structures of classification and categorization on demand, and then to describe any given situation by reference to categories that are doctrinally salient. The second intellectual skill is one that I have for a long time called the capacity for sympathetic engagement with counter-argument, the ability to put oneself into the shoes of one's adversary and to view the world through their eyes. Now, how do we develop these skills in our students? Our core pedagogy is the case dialogue method developed by Christopher Columbus Langdell at Harvard more than a century ago, sometimes described as the Socratic method. The key feature of the Socratic method is actually not what the professor is doing at the front of the room, which is asking questions. It is rather what the students are doing. Instead of passively receiving information, whether data or theory, our students are actively practicing the skills that they will be called upon to deploy when they are lawyers. They are speaking. They are inferring principles from patterns of decisions and applying them to new situations. They're describing rules in terms of the policy values that they promote and the policy values that they frustrate. This is a picture of typical approach of students in a lecture class, sitting, looking puzzled, wondering, and ultimately taking notes. This is a picture of students who are being taught by the Socratic method. Our students actually stand up when they answer questions, which is somewhat interesting. And they speak. They speak their mind, they offer their own thoughts, they offer their own ideas. They face professors and they respond to difficult questions, and this is an entirely new experience for them. So is the notion of working together in teams, which we also require them to do quite often. Now, this is important for a number of reasons. I happen to think, as a matter of pedagogy, the best learning, the most effective learning, is active and not passive. Jeremy Lin did not learn to play basketball by reading a book by Kobe Bryant or taking notes on lectures by LeBron James. He learned by studying and also by practicing. And that's what our students do when they are taught using the Socratic method. I guess I would say I'm also persuaded by the theories of cognitive neuroscience of Jeff Hawkins, which hold that our brains learn intellectual things in a remarkably similar way to the ways that they learn athletic things. Now, teaching by the Socratic method, as I say, is not new for our professors, but it is very, very new for our students. And they love having the opportunity to be taught in this way. And they make their excitement about studying in this way obvious to their teachers. They participate actively and enthusiastically in class. They come to see the teachers during office hours. And our professors say that they enjoy teaching these students as much as they've ever enjoyed teaching any students because the students' intellectual curiosity is infectious. So that's part of why these teachers want to return. The second reason why our professors keep coming back and why they recruit their most distinguished colleagues to come with them is that the students are enormously talented. When we started out, we did not know whether we would be able to get excellent students to come, since we are so very non-traditional as a Chinese law school. But our first group of famous foreign professors was enough to trigger fantastic buzz for STL, especially since we are a part of Peking University. And so we were able to attract, from the beginning, the very best students in China. And in a country of 1.3 billion people, the very best students are really, really outstanding. That fact has also made our top professors want to come back. They want to have the chance to teach truly exceptional students, students who will make a difference in China in the future, to have them be highly engaged and curious, as I mentioned before. What more could a teacher want? So we now have a virtuous cycle. Spectacular students attract the best teachers. Spectacular teachers continue to attract the best students. But the third reason why I think our professors want to keep coming back is maybe the most important of all. And it has to do with what our school is not, rather than with what it is. So here's a slide. March 12th is Arbor Day in China. And so this is actually a picture of us planting trees on campus a couple of years ago. And I like this image because it is so tempting to believe that the right metaphor for STL is transplanting a fully grown tree into an environment that simply accepts the tree without change. An American law school plopped down in South China. And this is wrong. This is not what STL is. And every professor who teaches at STL, I think, comes over thinking that it's mostly going to be a transplant, and they quickly discover that that's not right, and they find the reality to be much more exciting. So this is a scene from our orientation week. We have everyone read Antigone by Sophocles in English. So we have Chinese students reading a Greek play in English translation, which is wonderfully transnational. This is a picture of a performance of the play that our students did one year. Let's see if I can get this. Yep. This is a picture of a mock trial that the students put on at the end of orientation week. They were trying Antigone for treason, for having violated Creon's law. This is actually Creon on the stand here on the right, with three judges, a three-judge panel there watching. What was so remarkable about this experience was that everyone in the audience who came from the West realized that they were thinking about a play that they had actually read many times in new ways, because the question of what Creon was doing and whether it was legitimate or not, the question of what sovereign legitimacy actually means, feels different when the background in the room, the shared vocabulary of everyone in the room, is not Greece or America, but rather is contemporary China. Okay, here's another picture. We like to have parties at STL. We celebrate holidays at STL that are celebrated in the US. This is St. Patrick's Day. You can see our students dressed in green shamrocks on their cheeks. Looks like it could be a St. Patrick's Day party, but it was actually different in a couple of ways. None of our students wore green hats. If you need to understand why, I'll explain that later. And this is the only place I have ever seen people sit and eat Irish stew with chopsticks. It's a Halloween party. We celebrated Halloween. At this party, the prize for best costume went to the man in the middle, the guy with his pants with the waist up around his armpit. Now, when he walked into the room, I did not have any clue who he was. But everyone else in the room who was Chinese was convulsed in laughter. Why? Because he was dressing up as a caricature of the former president of China, Jiang Zemin, who is notorious for having worn his pants too high. Now, I think there's something moving about these scenes. I think they capture something important about where the transnational legal profession is heading, where transnational legal education could be heading. As an American, I believe that in the 20th century, American law schools made important contributions to the state of the art of legal education. I think we actually improved the way that the world helps lawyers to develop the skills of critical thinking, of sympathetic engagement with counterargument, of effective problem solving. We strengthened our focus on how we prepare lawyers to be ethical professionals. I think that in the coming century, we all stand to learn something from experiments like STL. So, for starters, we need to help our native English speakers to be more sophisticated about language, more sophisticated about the English language. In an era where the English language has become the lingua franca of commerce and law, we need to teach our students who are native speakers of English how to understand statements in English by people who are not native speakers of English. Often people who are not native speakers are using English words to express ideas that have their origins outside of Anglo-Saxon culture, and a listener whose frame of reference is limited to Anglo-Saxon culture may miss subtleties and nuances that are important. And that is not the speaker's problem. That is everyone's problem. And we want to make sure that audiences now can deal with this new reality. The importance of deeper cultural understanding, I think, also goes well beyond language. We need to help our students understand that there are multiple legal systems in the world and multiple legal cultures. We need them to appreciate the relationship between approaches to law and deeper cultural attitudes, such as the way that individuals are taught to react to ambiguity, to contradiction, to risk, such as the different ways that different cultures express respect for other people. Over the course of the past decade, books like Richard Nisbet's The Geography of Thought have motivated much deeper attention to the ways in which people who are born with the same wiring can end up with different cognitive frames as adults by virtue of the cultures within which they are raised. Those different cognitive frames can lead people to be aware of and focus on different dimensions of reality. In the 21st century, the people who are aware of those differences will be the ones who are most adept at bridging cultural differences and facilitating more powerful and creative multicultural teams. So permit me to close with one final simple example of a cultural difference that I stumbled on accidentally in the course of my work in Shenzhen. This example has to do with how Westerners and Chinese people deal with units of time. So if you were to ask a Westerner what day tomorrow is, 99% of them would say it's Tuesday. If you were to ask a Chinese person, 99% of them would say it's the 6th. For Westerners, the most important time interval is the week. For Chinese, it's the month. So if one of my colleagues, one of my Chinese colleagues, says to one of my Western colleagues, why don't we get together for coffee on the 8th, which is a natural question for them to ask, that question does not trigger a calendar to pop up in the mind of the Western colleague. The American will probably respond, the 8th. Do you mean Thursday? And then the Chinese colleague will go, yep, I think that's Thursday. And then the American will go, okay, no, I'm not free. Could we do it on Wednesday? And the Chinese colleague will go, the 7th? And the American colleague will go, yeah. And they go, okay, fine, let's do it Wednesday afternoon. I love this example because neither culture attaches any ethical or moral significance to which period of time you use by default. But once people understand the difference, it then becomes much easier to become much more effective and efficient. Americans at STL have learned to frame things according to the day of the month without any emotional anxiety when they're talking to their Chinese colleagues. Chinese colleagues have learned to frame things in terms of the day of the week when they're talking to Westerners the same way. In the 21st century, this kind of cross-cultural adeptness will become ever more important to ordering people's private lives. But I want to conclude by stressing that it will become still more important for people as they work in the public sphere. Autarky is extinct. All the peoples of the world are now indissolubly dependent upon one another. So pursuing the public good now means pursuing a global public good. Those of us who participate in the design of legal education need to think hard about the implications of this reality. We want to ensure that the next Sir George Turner will have the skills that she or he needs to make the same kinds of contributions that the last Sir George Turner made. We want to be confident that we are still helping leaders to develop the capacities that they require to lead in their own times. Thank you.
To be brief, thank you very much for joining us at the Melbourne Law School. Anyone who begins a lecture by talking about the spiritual mission of law schools is onto a good thing. We can reassure you that had we had a chance to speak beforehand, we could have told you that Sir George Turner was going to be fine because he was a Premier of Victoria. They're all ethical, they're all entirely decent human beings. I really enjoyed this evening, and I suspect so did everybody else in the audience, to hear someone talk about the road less travelled educationally, a brave experiment, the notion of teaching, simultaneously teaching students in 2 languages, in 2 degrees that cross-cut in order to produce students who can, or graduates who can be brilliant both in a US legal context and in China. And bring those skills together is just fascinating. And I guess many of us were thinking as you were talking about the intellectual journey those students are taking, not just while they're in your classroom, but as they take those 2 bodies of knowledge through their profession and their life, and what they will make of it over time and how they will use it. The experiment you described is a really important one. I think we all draw many lessons from it. I'm surprised, in response to that very excellent question about what have been the impacts, what's been the influence in the rest of China, that it's taken a while for other institutions to see the change. But then we know from our own experience that you can make major changes, and it does take a while, both in communities and in a profession for it to be understood. What you're doing will be hugely important. So on behalf of all of us, on behalf of the Melbourne Law School and the University of Melbourne, can I say thank you very much, Professor Lehman, for joining us. Thank you for a great lecture, and we hope that this, your very first visit to Australia, proves enjoyable and rewarding. Thank you. Thank you.